So, ladies and gentlemen, I think we have still four papers to go, and then we will have the final panel in which we will discuss the private equity and joint ventures. There are still some remarks on the performance optimization and the eco ships, which concern also Mr. Zanini, Varsila's general manager paper, and then there are two papers on charter parties and liening by English lawyers, and then we have a paper by Mr. Galizzi, who is speaking about a little bit the same of what Giorgio Berlingieri about maritime law has been, with reference to the international commerce, about the UNIDROIT principles. And I would like to ask him to start. You all know Pietro Galizzi, who has been participating to shipping and the law from its start, and he's the general counsel of Saipem, which is one of the largest European offshore players. So I would like to ask Mr. Galizzi to go ahead with this paper.
Thank you, everybody. Good evening. Thanks to Francesco Lauro for inviting me. As you mentioned, I will have a very few words on behalf of Saipem. Let's say we now, as one of the biggest ship owners in Europe, maybe the biggest in terms of tonnage. As you maybe know, we have around 40 vessels performing basically oil and gas activities all around the world. And in the recent years, we had a number of investments, a number of significant new vessels, and we had to face some problem, in particular with reference to shipbuilding contracts. And this is why I will tell you a few words about these UNIDROIT principles, which are something I came across in the recent past. UNIDROIT, maybe you know what UNIDROIT is. We are talking about the International Institute for the Unification of Private Law. Is a very important institute, which is a city in Rome, and they try to make a law for uniforming the regulation all around the world. Basically, in 2010, they issued the new version of the UNIDROIT principles referring to international contracts. Very, very interesting, because they are introducing concepts which are very important and very useful, and they get something both from a common law system or civil law system, I would say the best of. Let me say that when I came across the principles, I started reading and I thought about work by professor for university. Nothing to be ready to be used in practical terms. I was completely wrong, because I came across a number of rules were really applicable to our market. And I will give you some examples. Just let me say that, of course, you can apply the UNIDROIT principles if you have a provision saying that you apply the UNIDROIT principles. But in the practice, in particular international arbitration, even if they were not indicated in the settlement of disputes clause or in the governing law, a number of times the arbitrators, for instance the ICC arbitrators, referred to these principles in order to understand how to solve a dispute. So they are something already in the practice. Very, very few general idea about these UNIDROIT principles. As you can see, there is a particular reference to good faith, which is not a common law principle, but is a civil law principle. But apart from good faith, generally speaking, there is a reference to everything which is reasonable. And this is very important. So, going to something very practical. I will give you a couple of examples where, as a SAIPEM, we could have used these UNIDROIT principles. Unfortunately, they were not the rule governing our contracts, and I will explain you why. First of all, with reference to cancellation of shipbuilding contracts, I go back to what William Cecil earlier on mentioned, and in particular, he said, ship owner cannot cancel before cancellation date, even if inevitable, that vessel will be late. We had a case like this as a SAIPEM with one of our companies, which was a Portuguese company. We were building a ship in South Korea. The English law was ruling the contract, and at a certain time it was clear, very clear, that the shipbuilder was late. And there was nothing we could do under English law. Theoretically, we had to wait up to the delivery date, let's call it to the cancellation date, before we could do anything. Then, under UNIDROIT principles, there is a fantastic principle which refers to anticipatory non-performance where it's clearly stated that where, prior to the date for performance by one of the parties, it is clear that there will be a fundamental non-performance by that party, the other party may terminate the contract. Now, you understand how useful this provision could be in our market when we have to deal with shipbuilding. It would be definitely important. And similar, different case, but similarly we see how this principle could be useful in our market. With reference to the threat, we had a case, we had a company, a contractor building a vessel for us. Of course, they were in delay, they were not performing well, so at a certain point we decided that we had to take that vessel and bring it to another yard. And of course, the vessel was in their yard, they were not ready to deliver this vessel if we were not ready to pay a significant amount of money, completely undue, believe me. So we had to sign a settlement contract. And we were definitely what I would say under threat, under duress, you would say, in English law. Now, you know that under both English law and under Italian law, it's completely difficult to say that that settlement was null and void because of a threat. Because basically, under both English and Italian law, you need a physical threat, not something psychological. You could have it theoretically, but it never happened. Then, under UNIDROIT principle, you have a clearly statement saying that a threat can be a reason to cancel and to declare null and void a contract. And in the guidebook, explaining what the principles say, there is a clear indication that also an economical threat can be a reason to declare null and void a contract. So for us, it could be very, very important to have a similar principle in our projects. So this is why I tell you already that as a big ship owner, as somebody who invests a lot in vessels, in new ships, we are going to apply where we can, when we can negotiate it, the new draft principles. And basically, we are going to propose a settlement disputes clause where we say this contract shall be governed by English law, which is our case today, supplemented when necessary by UNIDROIT Principle 2010. This is in order to start introducing these principles in our market. But I definitely would love if in the future we would have this as the governing law for our contracts. Thanks very much.